Thank you. Thank you. Thank you, Ted. Thank you all. Thank you all very much. Thank you. Thank you. For the chief executive or any other constitutional officer, the duties and boundaries of the Constitution are not just a set of helpful suggestions. They're not just guidelines to be observed when it's convenient and loosely interpreted when it isn't. For decades now, some federal judges have taken it upon themselves to pronounce and rule on matters that were never intended to be heard in courts or decided by judges, with a presumption that would have amazed the framers of our Constitution and legal reasoning that would have mystified them. Federal judges today issue rulings and opinions on policy questions that should be decided democratically. Assured of lifetime tenures, these judges show little regard for the authority of the President, the Congress, and the states. They display even less interest in the will of the people. The year 2005 also brought the case of Suzette Kelo before the United States Supreme Court. Here was a woman whose home was taken from her because the local government and a few big corporations had designs of their own on the land she was getting, and she was getting in the way. There's hardly a clearer principle in all the Constitution than the right of private property. Then there was the case of the man in California who filed a suit against the entire United States Congress, which I guess makes me a defendant too. This man insisted that the words "under God" in the Pledge of Allegiance violated his rights under the Establishment Clause of the First Amendment. The Ninth Circuit Court agreed, as it usually does when litigious people seek to rid our country of any trace of religious devotion. With an air of finality, the court declared that any further references to the Almighty in our pledge were, and I quote, impermissible. And it was so ordered. Generations of pious, unoffending custom, supposedly overturned by one decree out of a courtroom in San Francisco. And now it turns out the same litigant is back for more in the Ninth Circuit, this time demanding that the words "in God we trust" be forever removed from our currency. I have a feeling that this fellow will get wind of my remarks today, and we're all in trouble when he hears that we met in a chapel. Senators Obama and Clinton have very different ideas from my own. They're both lawyers themselves and don't seem to mind at all when fundamental questions of social policy are preemptively decided by judges instead of by the people and their elected representatives. Nor have they raised objections to the unfair treatment of judicial nominees. For both Senator Obama and Clinton, it turned out that not even John Roberts was quite good enough for them. Senator Obama in particular likes to talk up his background as a lecturer on law and also as someone who can work across the aisle to get things done. But when Judge Roberts was nominated, it seemed to bring out more the lecturer in Senator Obama than it did the guy who can get things done. He went right along with the partisan crowd and was among the 22 senators to vote against this highly qualified nominee. And just where did John Roberts fall short by the senator's measure? Well, a justice of the court, as Senator Obama explained it, and I quote, should share, quote, one's deepest values, one's core concerns, one's broader perspectives on how the world works, and the depth and breadth of one's empathy, end of quote. These vague words attempt to justify judicial activism. Come to think of it, they sound like an activist judge wrote them. And whatever they mean exactly, somehow Senator Obama's standards proved too lofty a standard for a nominee who was brilliant, fair-minded, and learned in the law, a nominee of clear rectitude who had proven more than equal of any lawyer on the Judiciary Committee, and who today is respected by all as the Chief Justice of the United States of America. Somehow, by Senator Obama's standard, even Judge Roberts didn't measure up, and neither did Justice Samuel Alito. Apparently, nobody quite fits the bill for an elite group of activist judges, lawyers, and law professors who think they know wisdom when they see it, and they see it only in each other. I have my own standards. I will look for people in the cast of John Roberts, Samuel Alito, and my friend, the late William Rehnquist, jurists of the highest caliber who know their own minds and know the law and know the difference. My nominees will understand that there are clear limits to the scope of judicial power and clear limits to the scope of federal power. There will be men and women of experience and wisdom and the humility that comes with both. They will do their work with impartiality, honor, and humanity, with an alert conscience, immune to flattery and fashionable theory, and faithful in all things to the Constitution of the United States.